ensure that personal data is collected for specified, explicit and legitimate purposes, and not to be further processed in a way that is incompatible with this purpose. So you collected data originally, maybe to provide a service to a customer. Right?
For this event, so we have your names to know who is coming to attend this event, and you are given your names for that.
For that event, so you have called out, so we have your names, and you're okay with it. It's fair. We need your names, right? And then so imagine if we now sell your data to another company, right? That will be for a different purpose, right? And that will be wrong, right? We wouldn't do that, okay? Practice what we preach. We wouldn't do that, okay? So there are ways to use data for another purpose, but there are things to do if you have to use for another purpose. Alright? So it says that further processing shall not be regarded as compatible if it overrides the rights and interests of the data subject and it has no basis in law. So basically, if you are going to use it for another purpose, it should not affect the rights and freedoms of the data subject, or it should, unless you have another legal basis to rely on. So this is the pandemic, right? When people take COVID tests, there's a system in place supposedly to record number of people who contracted COVID. That's how globally we got the results, right? So number of people in terms of statistics. That was in the public interest. So based on the national law, the government had required that information was captured at that time. Does that make sense? So if someone says, I went for a test and the hospital now passed all my details, the statistics, right? Then when you say, no, it was in the public interest, because at the time I was a data protection officer, one of my clients was a data protection officer for an organization that carried out COVID tests. And one of the requirements then was to submit results every day to the government, right? But then again, of course, we still have to think about data minimization, right? When you say statistics, how many people contracted COVID? In terms of what's published, we don't see their names, right? Unless there's some other reason.
Also, so like making it more, so like hiding some details.
Absolutely, so you can hide. So, and the second one for scientific or historical research purposes, right? So that could be another reason whereby data could be used for another purpose. And 3, statistical purposes. Alright? So basically, you've all attended the session and we're going to take numbers, how many people attended the session. That will be for statistical purpose. We're not going to say, can we use your data internally? We're going to ask you for permission internally so we see how well the session went. Right? So statistical purposes. Alright, so these are like exemptions. So to be lawful if you rely on one of this to use it for a different purpose. We need to think about ways of reducing the risks. So normally what we need to think about is when processing data in general. I normally say, okay, naturally I'm an optimistic person. So naturally I'm very optimistic, right? But when I'm putting on my data privacy hat on, I have to be pessimistic, right? In the sense that I have to be very pessimistic, I have to be proactive instead of reactive. So think about when I'm speaking to clients, how did we get this data? Is it lawful, right? So we have to think about what could possibly go wrong each time. So while we're sharing this data, what if there's a data breach? Or while we're collecting this much amount, what if there's a data breach? So even when it's lawful for you to collect data, you need to think about minimizing data. Let me give an example internally, right? Let's say you have thousands of customers and or clients, and you have to share data, or even a few clients. You have to share maybe a case between your colleague, right? Information about a group of people within your colleague. Now, when sending it via email, or maybe you have a database, right? Instead of sending like a database of, okay, the names of the clients, the email address, the reference number, all as a database. Imagine if there is a data breach. how much information will go. What I would say is think about how you can minimize it, minimize the amount of data. So it might be like make a reference, list your client's reference details with information. So that's a way of minimizing the information. That reduces the risk. So that in case there's a data breach, rather than people just saying, let's say it's printed out and just see the information out there, right? So if people just see maybe the client reference number and the case, that reduces the risk. So somebody that does not know what that reference number means, it will mean nothing to them. Does that make sense? Right? So that's one thing about data minimization. Maybe like e-commerce companies, establishments, they say that it's our customers that give us too much information. So maybe somebody contacts customer service. How come my credit card did not work? Fine, attach my credit card. This is what I used. Right? You don't need to have that credit card. So sometimes they are the ones that provide that information. So we have to think about how we can reduce the amount of information collected to what is necessary. Right? As well. So 5 strategies. As I mentioned, think of being proactive, not reactive. Think of, well, when talking privacy, think of being pessimistic, not optimistic, in the sense that what if this goes wrong? What should we do? Right? What if there's a data breach? So think of how you can be preventative. Okay? So storage limitation. So this means we should think about storing data. Don't store data longer than necessary. But also, don't delete data before it's being required as well. Well, how do you know how long it will be necessary to store data? How do you know? Can anyone answer? How would you know how long is necessary?
Until the purpose for collecting data.
Thank you. Until the purpose. How do you know the purpose? Okay, that's right. I'll hold on with that until the purpose fulfilled. That's right. Okay. Anyone else? How in general?
Hasn't spoken.
Okay. So how would you know how long would be right to hold on to data? Okay. Let me give an example. If you make a purchase, right, or if you carry out a transaction, your bank stores information for a period of time. How would the bank know how long to store your data or when to delete your data?
I think there are laws.
Absolutely. Yes, that's it. Yes. According to the local laws, right? So if you think, so you have to, everyone has to think about the local laws, right? If you're talking about employee data, how long should you store their pension details, their bank details to pay them? So based on the local laws and for the different purpose, which is what Minister also talked about. Okay, so you know what to do. When you're thinking about this, like what we do with our clients is to have a retention policy and retention schedule. So what type? So you need to carry out factual due diligence. What kind of data do you store for your employees as well as your customers or your clients? Then from carrying out the factual due diligence, carry out the legal due diligence, which laws are applicable. Then you have an idea how long to store data for. Even as much as like in the UK, under UK law, for storing applicants' application forms, right? For unsuccessful candidates, we know how long to store the data for, right? And this is to the employer's benefit sometimes. So if someone applies for a job, is unsuccessful and says, you know what, I'm no longer interested in working in your organization, delete everything. The employer can actually say, no, based on the Information Act, right, we will store your data for up to 1 year. Because what if they delete the data, then the individual complains, I was unfairly treated. You have no interview notes to check. Do you see what I mean? So that's why I say it's not only about storing data for a period, deleting data too early, right? We just have to have guidance, which laws will be applicable. But you know what, it's important to document this. So it's not just thinking about it, it has to be recorded. So why have you chosen this? So we need to have justification for the retention period.
Taking on programs for the digitization of their organizations. So again, this comes down to your processing agreements between your controllers and your processors. In some cases, some of these companies are actually working with third parties to improve their storage or how they can store a lot of this data. So it might actually be informing those clients that, you know, there's going to be a digitized version of this or something like that. So as you said, your internal policies and your organizational measures are important, and to an extent the law does place it on you as a company to come up with these measures so that there's integrity and so that there's also some sort of accountability that it is on you to make sure that you put the right technical measures in place.
Thank you very much.
Sorry, I have a question. Further to her question, I want to bring down her question down to those of us in litigation that file processes in court and the matter dragged from the High Court to the Supreme Court. And at the end of the day, the information in the files are still kept by the lawyers and all that. What if at the conclusion of the cases and maybe in future, the client comes to say, I did not give you the right to keep my data beyond conclusion of these cases?
All right, now there's what they call legitimate interest. We're going to talk about that. I won't answer it fully, we'll bring it up again. Okay, so there are different lawful bases. So it may be in the legitimate interest of the law firm to hold on to that data if they can justify why. I'll leave it there. All right, we're going to have an exercise. So when we take a break, prep the exercise. So you choose that topic that you will carry out a legitimate interest assessment for what you just pointed out. Okay, good question. Great. Data accuracy. Can anyone guess or what does data accuracy mean?
And the data you're processing must be accurate.
Okay, I don't use word accurate. Correct, yes, and?
Factual.
Yes, factual, correct, factual, and? Fantastic, up to date, and well, that's the main thing. So correct and up to date, right? So imagine if you attend training internally in your some years back. She said, "Oh yes, I remember. I have an example. This is a lawyer. She said that she received a hand-delivered letter of a penalty. She had to pay 700. She was told to pay 700 pounds because in London, she drove into London and did not pay for a congestion charge. Normally, if you drive into London, there will be a congestion charge for maybe about 30 pounds or 40 pounds, right? That you need to, less than that for the day. But if you don't pay, then they send you a notification, you did not pay, so you pay 30 pounds. Now, when you get a letter, if you don't pay, maybe after 2 weeks' time, it doubles. A month's time it doubles, just keeps on doubling. Then they take you to court, and then they now send you to bailiffs. I've been a data protection officer for bailiffs. I'm not as well. These are enforcement agencies that were acted on behalf of the government, right? For people that owe the government. Now, so basically, when it got to the bailiffs, then they now checked. Basically they handed in that letter. So she was like, I don't even know what this is about. 700 and something pounds. So she looked at the order, she contacted the court. I don't know what this is. So following investigation, they realized that Transport for London, when they issued her the notification, they sent it to her previous address. But she had updated her address with the DVLA, Driving License Agency. So Transport for London should have checked. Their system, rather, should have had done this automatically. But somehow there's something wrong with the system. Right, it just picked up at an old address that was used before. So you can imagine because of inaccurate, dated or not up to date, how it affected that individual. So the court actually told Transport London, no, you have to reverse this, issue a note, start all over again, issue a notice to this person again, go back to £30. And then let me tell you what, the next thing, this person traveled, a friend of hers called her and said, your car's been clamped. They're ready to tow your car. Because she was not home, she did not see the hand-delivered letter. They still make the mistake again, right? So this time, she didn't have the time to argue. She just called up and paid because she was at home. She didn't want the kids to her account taken. But when she came back,
700.
yes. Imagine being on holiday and you pay 1.4 million before something that is not your fault.
Yeah.
Right. But when she came back, she now called them and they said, oh, sorry, apologies, this is an error. Anyway, a few weeks later, she attended the course. I said, well done, you got your money back, right? Is that all? When they did not comply with the data accuracy principle. I gave her some tips from the class like this, right? So what to do? Guess how much she got compensated? Because she went back to transfer money. Actually, regarding this, it was your fault. Guess how much she got compensated?
How much?
3,000.
But how did they get her new address to send her the letter?
No, okay, good. Let me mention. Now, what happens, as I said, I was a DPO for an enforcement agency, so debt collector, so I know how they work. When a government agency passes on a claim to them to say, go after this person for this amount, when they send the first letter, if they don't hear from you, they start doing their research. So they now use tracing agencies
To trace her new address.
to trace her new address. Or that's how it works.
They're incompetent. Because when they found her new address, they would have knew that something was wrong, that the initial notices they issued won't fly.
That's the thing here. That's not Transfer London. This is the debt collectors doing their thing. Do you get what I mean? And that's where you're right. That's why privacy law matters. You need to know your. So this is what I always say. By the way, the lady that I gave advice, I didn't get anything from that. Good for her.
Is there anything wrong with dropping handwritten notice? You know that they dropped it like a letter, and she's not around. So what made it wrong?
No, what happened was she wasn't around, so she did not even see it. If not the first time, because she was around, she saw it and she could complain.
Yeah.
So that letter would say, sorry, actually I mentioned what the letter said. If you don't contact us within 48 hours, we will seize your car. Right? So because she didn't see that, she didn't.
What I'm saying is, does that mean dropping letter like dropping?
It's not wrong.
No, the dropping letter.
So that means it's her problem. Because if they dropped the notice
No,
to
you're
you
missing it. No.
in your
One
correct address now,
No.
they don't drop.
No, the main thing is that
Must they use for?
So, let me explain. We're talking about transparency here, right? Okay. Now, initially, they were meant. If you're meant to make a payment, they should have told her. They should have notified her. Supposedly they did, but she did not get it, and it was their fault that she did not get it. Because they sent the first letter to the wrong address.
And now they brought it to the right address and dropped it.
7 months later, after the penalty has increased. So that's what the court said. Send it, reissue it again, but bring it down to 30.
I'm not
So yeah, good.
I have an example. The government agencies, and they do some of these things, maybe they do it. Because of my age, I don't know whether there's a fraud going on. I'm not supposed to be paying land use act in my house, which I'm occupying personally. So I got a land use charge invoice notification. So I asked one of the guys in the office, you got to go there. They put the payment ID and they put the customer ID and they put my name. When they got to the bank, they said, hold on, this payment ID and does not correspond with this name. We went back to Lagos State and said, this is not correct. They said, oh, it's our mistake. We have still not been able to make that correction. But I refuse because I think there's a fraud. They know that I'm not supposed to be paying you. So I would have now raised the invoice on my name with a different ID. You are paying me without looking at it. They will be going to a different account.
A different account, yes, correct.
So they came back again and said they've done something. I said, but what is wrong with my old payment ID which I've paid for years without a problem? So you have to be careful the kind of this accuracy and go. They wanted to direct us to their own bank Ibile holding
Was
something.
fraud.
And they've been calling and saying, oh, you should go and do it. They were not. So you have to be careful. Some of these things are, if you have to also pay attention to the area of data accuracy. There's one that is pathetic that I'm handling right now. The person went to a judgment, there's a dispute on a land. And the three people went to court. And somebody won. When the land in question is not fenced. So when they wanted to pay the judgment or notice or something like that, they found another land that is fenced and they put the notice there. And they've been going to the court to say, look, this guy, this is wrong, friend. If I was there, I was going to go and just pay people. Now the guy that won, he wants to take over a land that is not his own. They got the judgment against that house. They couldn't access it and they placed it there. And somebody now said this is now happening. So those are the kind of useless things that happen. But it all has to do with accuracy.
How are you securing your data? Is it appropriate? You have to be able to justify that this measure is good enough, right? So that's where this comes in. When thinking about security, there's one statement I like saying: you can have security without data protection, but you cannot have data protection without security. What I mean, okay, you can have security without data protection, but you cannot have data protection without security, right? You can secure your home, right? It's not only because you want to protect your data, but when you're thinking of protecting your data, you must have a security measure in place, like lock and key, password protection, encryption, two-factor authentication, and so on, right? So when we're thinking about security, we have to think about these three: confidentiality, integrity, and availability. How can we secure data? Confidentiality means restricting access on a need-to-know basis. Restricting access to files, restricting access to documents, restricting access to buildings, rooms on a need-to-know basis. It's not just because, oh, we trust, we're like a family here, everyone shares the same key. If there's a problem, how do you investigate when everyone is sharing the same password? Right? So restrict access on a need-to-know basis. Sometimes it may be role-based. In your organization, maybe everyone needs to read a file, but not everyone should be able to make changes to that file, right? So that's confidentiality.
So I'll actually give an example of this. So in our firm, we recently started or hired the services of a tech company that helps with our workflow management. So a lot of the time, if we're given our tasks or reports, you have in your law firm, you'd have different lawyers in different departments or different practice areas, and it's the same thing. So now, as opposed to having your files in all your practice areas, we now have a lot of these things online. So basically what happens is the different lawyers have access to their different practice areas, and then let's say like the heads of the partners will now have access to oversee all the different ones. So in that case as well, I can actually send out a task to someone in the firm, and I can give them access to view a document within a practice area that they are not in, or just only that document. So the reason why we had to put a measure like that in place is literally just for this, as opposed to if you just had the file in the library in the office, anyone can just get access to that. So sometimes implementing these measures actually means moving along with the technology and moving along with the times to make sure that you have the security that comes with the data protection.
Fantastic. As you just mentioned that now, thinking about now, of course, you're all from law firms, right? So, but it's not just about, we also have to give examples of how you can protect your clients, how you can advise your clients as well. An example I will give is, okay, my son is also a data protection manager, right? And it's something he introduced some years ago, a couple of years ago, which I was quite impressed by. Was like, now at the time, he was a data protection manager for I'm going to keep things confidential, so a known celebrity brand, right? Not celebrity, sorry, designer brand. A known designer brand. So imagine, sorry, I'm going to go very informal here. Does anyone remember this case of when Jay-Z and Solange were caught on camera, right? Okay, that was CCTV maybe in an elevator, right? Now, how did that information get out? Okay, so I sort of thought about that because in terms of when I said designer brand, he could have been in that position, being a production manager. So he actually sets up the policy with restricted access. Not everybody can access their CCTV footage. Because otherwise, people could just, maybe a celebrity comes into, or a government official comes into a building and someone sends out the
footage.
Yes. So basically there's restricted access. So you can see how we can think about all of this.
Even the fact that CCTVs are not sharp.
Exactly.
Yeah.
So I don't know if any of you have noticed, but whenever you're looking at the CCTV camera, it's never as clear as your iPhone camera.
Sure.
But the technology of these cameras are actually, if not higher than the mobile devices. But there's a reason why they ensure that the resolution is not that high.
Data minimization.
Exactly. And you don't want to pick up what
you shouldn't
pick up. So for example,
Sound.
the example of, you guys know Ring, the doorbell, Alexa, so it's an Amazon product, and essentially when you ring someone's doorbell, it pops up with the camera, super sharp camera and whatnot. And in a situation, imagine you have a neighbor, I live here, you live there, my camera comes on and it's picking up the
people
video
entering into your
of
apartment.
house. And in one case, the camera was actually sharp enough to pick up some private information of another party, and then there was now a data breach of the actual Ring product. So through that data breach, they were then able to access some of these things and pick up some information which was then later used for fraud and other things like that. So it's just a case where data minimization has now linked or led to
Confidentiality.
Exactly. So you can see why in some cases it's important to minimize data, even if it's video data that you're getting from the video camera.
Thank you very much. So you know what, talking about that now, so we're talking about the risk, and guess what, under the GDPR, it says that to ensure security, where there's a high risk, we need to carry out risk assessments, right? And you know what, it's not just saying, oh yes, we carried it out, we discussed it. No, you have to document it. It's something that has to be recorded and reviewed. So you know what, even if there's no data breach, if you're caught out for not carrying out a risk assessment, this particular risk assessment called a DPIA, Data Protection Impact Assessment, you can be penalized for not being proactive, right? So,
and this is even if nothing happens.
Even if nothing happens, right? Okay, let me give you a good example. And there are criteria for when you have to carry out this risk assessment. There's a primary school somewhere in Europe that was fined 50,000 euros, and it would not really have empathy on schools, right? Why? Because the school had changed to collect fingerprints of school children for something. That was not the issue why you did that. But the requirement is that when you're collecting sensitive data like that, you must carry out a risk assessment, right? And so what's a risk assessment? Oh, parents gave consent. That's not about it. You should have carried out risk assessment. So that's 50,000. But even let's look at an example from Nigeria. Oh no. It's an assessment. So if you realize that there's residual high risks, you're not able to mitigate the risk. You know what? It's not all the time you have to carry out. I've had a client that carried out a risk assessment. I reviewed it. I said no. I think this is unnecessary. Getting this new system is unnecessary. Meaning there's a less intrusive method of achieving your purpose. And that was it. We thought about the less intrusive method and did not introduce that new technology, right? And at the end of the day, I think they were better off anyway. So it doesn't mean that, my point is that we should not think of a DPIA as a tick box exercise. Okay, we've completed it, let's get on. It's really an assessment. Are you okay with it? And if you're still not okay with it, you might have to even contact the commission and ask for advice. Right?
So just on the assessments, so in some cases, because not every company might have been data or privacy compliant or aware from the start. So not everyone would have been able to do a DPIA for products that they have already launched. So in that case, there's another assessment known as a gap assessment to basically ensure or check if there are any gaps or privacy gaps in the current system that you already have in place. So in some cases, when the regulators might fine you or they might reprimand you, sometimes they also just, tell you go and do these things or ensure that you do these things. And some companies, so a lot of the time when we get a new client who is now aware of privacy laws, some of the things that we would do would include a gap assessment just to make sure that the products that you already have in place are suitable.
Let's look at some penalties which we can associate with duty of care.
Okay, so in this case, the NDPC, so the NDPC is the commission that applies the Data Protection Act. Fidelity Bank was fined for processing personal data without the right consent. So remember, we spoke about consent at the start, and in some cases, even if you have consent, it could be decided that you haven't got a consent in the right manner or that it wasn't suitable enough. So essentially, they failed to implement adequate safeguards, so adequate technical measures. So those are the words, the key words when it comes to privacy that you need to look out for. And because they failed to put adequate safeguards in place, then they were essentially fined. So now the data controller, it's their responsibility to protect personal data, but let me get into that a little bit more. So we spoke about processing agreements. So when you process an agreement, it's essentially an agreement between the data controller or controllers, that can be more than one, and the data processor. So for example, as the data controller, I receive the data subject information. So I received your names, today to come to this, and I can pass that information on to a data processor who would then say, okay, I'm giving you this information for you to provide them the codes to enter the estate. So that, I have drafted an agreement and I've put that for the purpose. So that is the purpose. So what happens if they now on their own get that information and pass it to, I don't know, someone running for Lagos State government so that they can call you guys? That is now going beyond the purpose. So it's important because if that is not documented in a processing agreement, if they're going to come for someone for that information being leaked or breached, they'll come for the data controller. But if you're able to show, and again, the accountability part really matters, and show that it was documented, then you'll now be able to show that the processor went ultra vires of basically their powers or the powers that they were given for that purpose, and they took on the role of the controller. So they would then be fined as the controller in that instant. So that's why it's really important. And as a lawyer, just like you guys, I get a lot of time where I tell like my clients, like, you're a financial service company. Have you executed a processing agreement with these API providers? They're like, oh no, but we have a data protection clause in our agreement. And you look at the data protection clause and it's basically just almost like an NDA, like confidentiality. And you realize when you understand the principles that we've looked at today, that a clause cannot encapsulate all of this. So essentially you need that processing agreement. So if anything, what I'm actually focusing on here is the relationship between the data controller and the data processor and why it ties in. Like, I know this focuses on consent, but what I actually wanted to focus on here, because I don't think we've actually spoken directly on that, is that relationship between the controller and processor. So as a lawyer, you now realize that it's not just okay to put just a short paragraph, that you actually need to look deeper into this. So I'm sure you guys are already starting to see the role that you can play as a privacy lawyer and how you can help build a company's privacy compliance model.
Yes. Quite interestingly, yes, HA has focused on the role of the controller and processor. Later on today, we're going to look into data processing agreements, right? It's only more practical, and we look at the kind of clauses that could be in the agreement. A lot of the time, it looks like the controller is held responsible. But 6 months ago, in the UK, we saw the very first penalty where the processor alone was fined. Why? Because the controller was able to demonstrate that no, this was totally the responsibility of the processor. And this was for the NHS, right? So they had a processor, so the processor acts on behalf of the controller to provide the service, and they did not implement their two-factor authentication. That was what led to the data breach. So that was from the side of the processor, right? And so in that case, because the controller was able to demonstrate what they had in place, that they had carried out due diligence on the processors, had the agreement and all that, they had no penalty. That's the controller, but rather the processor.
And they can only demonstrate because of accountability.
Because of accountability, that's very simple, isn't it? All right. I saw.
Yes, I don't know if you explained that during the course of your lecture, but I want to briefly look at the difference between the data processor.
Okay, I'll say that. We're going to talk about it later on, but let me just say, a data controller is the party, either an individual or a legal entity, which could also be a government agency, that determines two keywords, that determines the purposes and the means of processing. Who determines how the data should be used, what purposes should be used for, and so on. And then the processor is, again, could be an individual or a legal entity that acts on behalf of the controller, essentially providing a service to the controller. Okay? So you have your marketing company, right? You say, help us carry out this marketing, right? You pass on, the controller passes on the customer's details. Can you send these emails on our behalf? It should be used for just this purpose for us, right? Now, both controllers and processors process data. I've had a client before that said, oh, but we are the controllers. Yes, but you still process data, okay? Processing is any action performed upon data, being collecting, deleting, destroying, transferring, and so on, right? And an organization may not need a processor for a certain activity. It's not all the time you need a processor. So you could have, for example, an organization carrying out payroll. Every organization pays their staff, right? If payment is done internally through your establishment, then you don't need a processor. But if you have an outsourced party carrying that out, that would be your processor. Good question, thank you.
Work in this particular that ordinarily you see them, your response will be, oh, this is an open source material. And this person has the license to put their work there so that people can easily access it and use it for development and whatever research that they want to do. Now, what are the foundation of copyright laws? Now, the foundation of copyright laws is based on several key principles, and one of the key principles is originality. And the reason why it is very important is because for your work to be eligible for copyright protection, it must be original and it must be fixed in a tangible medium. And when you say a work is original, there must be some element of innovation that makes a particular work distinct from another work. You can't just carry someone else's work and you say you want to copyright a particular work when it's not an original work. You'll be infringing on someone else's intellectual property. So your work must be original, and it's not just enough that you have an idea in your mind. For a work to be copyrighted, and for it must be fixed. So if your client is coming to you and say, I had an idea in my mind and I just saw that someone else has produced a particular movie, I want to sue that particular person. It's not possible. It was an idea in your mind. Never at any time you place it in a fixed medium. Never at any time you have any conversation with that particular person. And even if your client wants to have a conversation with a third party with respect to an idea that you have, we usually advise as a firm that there should be an NDA. Because it's important. As simple as that, you can equally reduce your NDA to a one-page document or a two-page document, but the real essence is that you want something that can protect your clients, that, oh, we had this discussion, and there were specific things you were not supposed to do with respect to these disclosures that were made to you, and now you're not using this particular disclosure. So, also, some of the foundations with respect to the copyright law is exclusive rights. Now, what it does is that if the copyright holder or if your client work is copyrighted or the minutes, you necessarily, one thing I really want to say is that you necessarily do not need to register your work in Nigeria copyright protection for copyright to subsist. Minutes is an original work, that is in a fixed medium, automatically copyright subsists in that particular work. So if your client say, oh, I created a work, I shared with the third party, and after that discussion, the third party went to use that particular work, you don't need to now say, have you registered the work with the NCC for you to now go and enforce your client's right with respect to those particular materials that we disclose that are now being used without permission from your client. The minute your client was able to put those particular work in a fixed durable form that were shared with any third parties that were used without the permission of your client, that is an infringement with respect to this particular work that your client has shared. Then, copyright has limited duration. Now, one thing that we usually tell people is that there are numbers of years for which copyright laws has provided, especially for literary works, musical work, artistic work. You have, if you are the person who created or generated that particular work, to tell you for 70 years of the author of that particular work. For the lifetime of the author, then 70 years after the death of the author with respect to this specific work. Okay, so authorship. Now, just like I said, with respect to when I was saying who has the copyright with respect to specific work, I talked about if you created a work as a single individual, you will be regarded as a sole author with respect to that particular work. Then there's equally work as work of joint authorship. You see sometimes, especially for music, you see people collaborating to do a particular movie, particular music. Even for movie production, you can see more than one movie production company coming together to shoot a single movie. Now, in those particular instances, you could say rightly that they are work of joint authorship. Though it's a collection of different individuals who, for a very short by virtue of their cast agreement, their crew agreement, their talent release agreement, the production agreement, would have defined who owns the copyright with respect to this particular work. So it could be maybe both production companies that will have the copyright. It could be 50-50 or maybe 60-40. I don't know how many persons have with respect to, I think it's, well, with respect to this particular case, Shantitan. You know, one of the disputes with respect to that particular case was with respect to who owns a particular percentage of the copyright. It's not the copyright. Who owns the copyright was not an issue. The issue with respect to that particular case was how many percent did you have with respect to this particular copyright, that it was a work of joint authorship. That was the argument. So the argument was not that they are not saying the producer of the company was the owner. They are saying no, I am a co-producer. So I have some certain percentage with respect to the IP rights of that particular movie. So revenues that are generated from that particular movies and all of those stocks should equally come to me. And when we're talking about producing the part 2 of Shantitan, I should equally be in the picture and sit in that table because I'm a co-producer with respect to that particular movie. I think that was the major issue. So I just want to have a bit of discussion with respect to AI generated works copyrightable. So I just want to ask something.
Can you take that?
Okay, I think she wanted to say something.
I would say it depends on the jurisdiction. There are some countries that consider it copyrightable, some don't, because who created it anyway, so I don't know.
Okay, she wants to say something.
I think first off, most of the products or the results gotten from AI are generated from open sources, different places, different authors, and you told us earlier that that copy left also connotes open source here. So I presume that you cannot boldly state that you can copyright AI generated works.
Many other person have a different view of the
Okay, so I believe that AI generated. Okay, let's stand up. Okay, I believe that AI generated information can be copyrighted only if there's been like advanced improvement on whatever you are getting, right? That's when I believe that it can be copyrighted. However, if you're just putting in a prompt and it's giving you back an answer and that alone, that's not copyrightable. I would like to add that you can give AI a prompt and it gives you a feedback, and then you go ahead to develop on that feedback. You then put it in another form. Let's say it gives you an idea of a movie, right? And then you go ahead and put it in a fixed form. I think it can be copyrighted.
I think this question is a very simple question. You ask AI generated was copyrightable. I think the answer is no. They are not copyrightable. So if they are, then that's why we're here, for you to do.
I really like that. Okay. Someone said something with respect to jurisdiction, and I think I want to take it from that particular perspective. Okay, currently in Nigeria, online. For AI generated work, the simple okay. But please respond to that particular person that he can share. Let's see what he wants to say. Since it's virtual, it's hybrid, so we should equally listen to them.
In the AI generated article or whatever, if the two perhaps we can say the outcome can be copyrighted. Thank you.
Okay, thank you for that particular contribution.
I think there's another person.
Okay, you can want to say something, you can go ahead.
So yes, in respect to if AI content can be copyrighted or not, I want enlighten the world that we understand that there are presence of things like generative AI. Let's take for example, you ask artificial intelligence to paint a picture.
I think some months back, I was on Facebook, and one lady was complaining and saying that she was unable to take a picture with her husband when her husband was alive. And her husband is late. She wants a picture of her husband holding her. And she spoke to the AI machine. And AI machine asked for one picture of her husband. And with that picture, created several pictures of her husband holding her in different places and different positions. So it could be that creative. But the primary issue I really want us to know, just like it was heard in one of the cases in the US, is that AI can really not be an author of a work. Because it's simple, the way and manner authorship has been defined by a Copyright Act is limited to human person and not machines. However, if there are some certain levels of human input with respect to this particular work, then that particular person that has made inputs to make that particular work original can claim authorship of that work. Someone will say that an AI machine is what a productivity tool, and as such it enhances your work. Whatever the inputs and whatever is placed there is for you. But just like she said, it now varies with respect to jurisdiction. Because a Copyright Act is silent as to whether or not a machine or an artificial intelligence can only work. It becomes difficult to see whether or not AI can only work within Nigeria. But there are some jurisdictions currently like Korea and some, I think China, that are now advancing in technology. I read somewhere also a situation where a monkey, I think Naruto, took a picture, set the camera, and the camera took a picture of the monkey. Who owns that particular picture? It becomes so does the Copyright Act in Nigeria in any way of definition ever foresee that an animal would act in that manner? We have pets that are smart these days, that can hold things, that can place things, that can even operate phones. So will you not say that the pet or the animal is the owner of that particular work? it all depends, just like they said, on the jurisdiction for which you're coming from. So currently within Nigeria space, we cannot say that an AI can own copyright with respect to any particular work. However, for other jurisdictions, that would be a different case. But if there are some levels of human input, then that particular person that has made such input, just like the recently said, in that work can claim that they are the owners of that work because their inputs has made some certain elements to make that work original. So you cannot really say in entirety that that particular work is AI generated because it's human input. Okay. Then, with respect to fair use, I know most of us, I don't know, I will ask generally, how many of us have had someone say, oh, fair use, or what do we understand by fair use? Because these are things, sorry. Yes, what is fair use? Okay, I've had fair use.
Yes, I've had fair use.
What do you think fair use is?
Because your clients will tell you, a lot of persons will tell you, oh, is this not fair use? Why are they suing me? Why are they citing me this and this later? What should be my response?
I just know it. I think fair use, in my understanding, is just being able to use someone's copyrighted work without the person's permission, like, to a certain level, to a certain extent. So my knowledge of it is just on the surface level, not necessarily.
Any other
Okay. So I've shared a video online that was flagged, and then I came under that that it was actually my voice in the video, even though it is the company's video. So I have the right to also use the video because it was my voice in the video. And that way the video was allowed to go.
Okay, I think using the instance of defamation, I think one of the defenses in defamation is justification and fair comment. That's where it's obvious that you actually made this defamatory publication, but I'm justified because it is true. So I think we can relate it with fair use and say, in as much as you have the copyright to this work of art, or I'm using it specifically for this and this and this purpose, and for that reason I think I'm exempted, to use this work as long as it's within this cadre, not outside of it, and it's not, for profit purpose or. I think I've made my point.
Yes, you have. Okay, someone else wants to say something.
Please, if you're not speaking, can you please mute your mic? Thank you very much.
So my understanding of fair use is simply limited to educative and informative purposes, where you're using someone's copyrighted work for educative purpose, which eliminates the profit making, or informative purposes, where you have things like people commenting, comments, reviews, and also parodies and caricature. So that's my understanding of fair use in a nutshell.
Thank you.
It's what fair use is. I don't know how many of us will, all of us here, we did project work, we did use the library, and we definitely did copy some things. And some persons even collected some people's projects. Just change back and front page and submit the project and all of that. But that's not the issue. So what is the amount of work that is accepted as fair use? Can you take my entire content, change my name and first and back page and resubmit and say it is fair use? And because it is just like you said, it is for educational purpose. And you're not selling it in the streets, buy your so and so law in contract or and that's for students. That's where issue of commercial, whether it's for commercial purpose, come in. Now we are equally seeing that in churches. How many of you, when you attend church, praise and worship, you really like it? It is not your choir people that sang that song. And they will sing, they will record it. They will share it on YouTube and all of that. Now what allow them to do that is this particular principle of so to public performance for religious worship and purposes falls under the category of
Kind of like what Nathaniel Bassey does during Hallelujah Challenge.
Hallelujah Challenge. So as a lawyer, and the lawyer was smart enough to say, oh, because to an extent we might want to monetize our YouTube streaming, and we have content with respect to several musical work of other individuals that will be singing, and we are not the authors of this particular song. We only need to put a disclaimer on the lyrics. Now, because you don't want someone to come after you and say you've commercialized their work, you're making profit from their work, and it's affecting their sources of revenue. Because that's it.
Yes, nothing to it. I can imagine how to show is of interest. Something that's going to be rushing. That really
Since the 80s. I have known about him since the 90s. And I know some people come and say they've known about him since 2000s. Yes. But the point really is that for me it's a privilege to actually be in this office. It's also a unique privilege to have sat with your dad the last 2 days. Yes, it's still because the end of Monday, end of Tuesday. And I actually said we'll come tomorrow. You have to go to Abuja to make money. And I'll be back again tomorrow. But on behalf of the MBA Lagos branch, we'd like to say a big thank you to OEL for this support. I've been to 3 masterclasses today, and I'll go to the other 4. When we see innovative things, we should, commend those behind them. And this is not a chance, it's something that you do. We know that you invest a lot in knowledge sharing, and I was excited when they mentioned that your firm had signed up for this. I'm very, very grateful. Sports is dear to me. Ben knows this, we know very well. If I was not a lawyer, I probably would be in sports. And I think in my new life, I find myself maybe in FIFA or in CAF, or something like that. And I think we are FIFA accredited. Yeah, before so please network with her. She'll tell us how to get into FIFA. Thank you so much.
We appreciate you coming around, and I believe you enjoyed the class as it goes on. Well done.